There's an interdict referred to in your statement obtained by Neil Diamond, who applied for an interdict after being harassed with intimidation and attempted extortion by Paul O'Sullivan. Copy is attached here, is M1. This was one of the reasons which you considered in coming to the conclusion that Mr. O'Sullivan will endanger the safety of other people or will commit a Schedule 1 offense if released on bail. You remember on that case?
Yes.
When you signed the warrant of arrest, I was not aware of the court order. I must be noted. I think that's you, am I right?
Yes, that was me.
As we speak now, all this harassment and intimidation, in your view, from your former colleagues, has it stopped now as we speak?
Intimidation?
Yes,
from
Paul O'Sullivan. Has it stopped harassing
I
people?
think as soon as he hears that the matter against him is going to possibly be re-enrolled, he's going to start harassing the prosecutors involved.
Now, earlier we spoke about the issue of the court order, which gives him a 48 hours notice before, if anyone wants to arrest him.
Yes.
Can you perhaps, in brief, that as we speak now, if he comes in here, the police have a case against him, they want to arrest him, is it impossible? They have to notice him.
Yes, they have to notice him in order to comply with the court order, unless maybe there is an urgent reason maybe to arrest him, and then we have resort to Section 35, subsection 5, in terms of the unfairness or otherwise, where we can go to court and say that this person was arrested and we had an extraordinary situation where despite the court order, we had reasons to arrest him immediately to prevent harm.
Now, in your view, do you have anyone, do you know anyone in this country who has that privilege?
No. No.
So it means that Paul O'Sullivan, like General Mkwanazi said on the 6th, to say our criminal justice system has been infiltrated, Paul O'Sullivan is one of those who, in fact, we are in this situation in this country where we are because of him.
Partly, so I know I have evidence that shows that he had infiltrated IPID.
Yeah, you are a seasoned career prosecutor. You have served the NPA for a period of 24 years and 9 months.
Yes.
And then you decide to leave the institution. Well, you are saying in your affidavit you don't want to disclose your current employment. I respect that. But I'm just interested in knowing, why have you decided to leave the NPA after serving for so many years? Was it out of frustration, or it was out of new opportunities that you identified to be better than the occupation you held at the time?
Yes, it's the latter.
So it was not out of frustration?
No, even though O'Sullivan tried, he did not break me.
You are saying you left the NPA when?
Effective 1 September 2024.
2024,
yes.
Okay. Now, you are saying, I think on paragraph 131, when you explain the reasons why the matter was struck off, you are saying in the next court appearance, you did not have warning statements of individuals against whom charges were supposed to be preferred. So who do we blame here? Do we blame you or the investigating officer?
Okay, I have the warning statement from some of the accused. The only warning statement that I did not have was that of Mr. McBride, because when the IO called him, he said, "Talk to my lawyers." Then IO asked him, "Who are your lawyers?" Then he dropped the phone, and then he never picked it up until he took us to the Zondo Commission. IO tried to trace him, look for him. He never got hold of him.
So was Mr. McBride not charged already? Because I was under the impression that the people who were charged was McBride and Sarah Jane. Were they not charged already?
No, it was O'Sullivan, Trent,
O'Sullivan.
Manda,
Okay.
and Temani
Okay.
Bina.
Okay.
Yes.
So you needed to add more witnesses.
More suspects.
More suspects. So
Yes.
I'm sorry. So those suspects were McBride and
I cannot disclose the names of the suspects until they appear in court.
how many were they? The outstanding witnesses.
Yeah,
I mean, accused suspects.
They were at that stage 4, but we identified that there could be more, but then we decided that the others do not form part of the enterprise. They only did maybe one, were involved in one incident which could not be reconciled with being an enterprise as this other core group.
So that was in 2017.
Yes.
So from 2017 to date, it's difficult to add more witnesses.
No.
Have they been added?
No, because remember, there was this to and fro regarding the racketeering.
The racketeering,
On
yes.
the-
You said there are two aspects. You are saying in your affidavit, there are two aspects which led to a matter being struck off.
Yes.
The first aspect is that more witnesses had to be added. The
Yes.
second one is that you identified a charge of racketeering.
Yes.
I'm saying now on the first aspect, is it still difficult until today to add more witnesses?
No. If the matter is re-enrolled, you can add those suspects.
Yeah, because what I'm trying to establish here is why is it so difficult to re-enroll the matter now?
No, it's not difficult to re-enroll the matter. A decision just has to be taken, and then the matter is re-enrolled.
So why has that decision not been taken? The decision is supposed to be taken by the DPP, correct?
In terms of even racketeering or even a normal indictment has to be signed by the deputy director. So
yeah, but I'm trying to understand, Mr. Mashuka, where is it stuck now?
at this stage, I heard that there's a letter that the NDPP sent to Parliament to say that they have allocated a they are allocating a prosecutor to decide on the matter.
On the matter.
Yeah.
So a decision has not been taken.
Yes.
Okay. So when Mr. Paul O'Sullivan was arrested, how long did it take him to appear for the first time in court?
In court. When he was arrested, I had to go and appear in the High Court on an urgent basis because he made an urgent application to the High Court of Pretoria.
On the same day?
On the same day, yeah, at night, around 9 o'clock, I was there. And the basis was, I have this 48-hour notice order.
So the matter was heard on the same day?
Yes, was heard on the same day, and then it was agreed that either he must be released and then given a notice or taken to court.
At what time was it heard? You are saying you were there at 9 o'clock and,
Yeah, at around 9 o'clock in the
then a decision was taken
yes,
on the same night.
yes,
Who was was it in the High Court or Magistrate Court?
yeah. It was in the High Court.
Who was the judge who was presiding over the matter?
It was Judge Lehodi.
Or Judge Lehodi?
Yeah,
Okay.
he was a judge by then.
Okay. Let me trying to write it down.
But remember, he only had to interpret what was before him, which was a notice, an order that was not even made by him.
Okay. Now, the DPP, you are saying on paragraph 121, the DPP ultimately declined to prosecute.
On those
Yes.
two charges of
Yes, I'm just
DPP.
because I'm trying to save my time.
Yes,
I'm not going to read the whole paragraph.
no, I understand.
Is this jotting your memory?
Yes.
What I'm talking about? here?
Yes,
Yeah. So how do you view this? Was this genuine or?
it was never genuine because a person is arrested, her cell phone is seized in terms of Section 231A. He's taken to the cells. How can there be kidnapping and theft of cell phone? But I have a comparable case where they resurrected some previous cases against some of the investigating teams. Then they referred that case to the High Court, I think High Court in Johannesburg. My investigators got acquitted in terms of Section 174 relating to the theft of and kidnapping at the airport. There was a robbery at the airport. Then some of my investigators arrested those people who committed the robbery and seized the money. Then they were accused of kidnapping, and the High Court gave a 174.
So is that suggestive of a proposition that some in the NPA are in cahoots with Paul O'Sullivan or were in cahoots? If that is your interpretation of the situation.
No, it is McBride who went to resurrect those cases according to the investigating officers.
No, you are saying here, Mr. Advocate Mashuka, we are saying there is a memorandum that was written by advocates and wherein they were analyzing the prospects of success.
Yes.
And the inference that I'm drawing here is that the memorandum suggested that you can continue with the prosecution.
Yes.
And the DPP took a different position.
Yes.
Declined against the memorandum that was written by the advocates.
Yes.
Is that correct?
Yes.
Yeah. No, so I'm saying, is that now suggestive of a proposition that the NPA was also in cahoots?
Well,
or there are some individuals who were working in the NPA, not now in IPID, but in the NPA, there are some individuals who were working with Paul O'Sullivan.
Okay, firstly, in terms of the decision, it is not wrong for different prosecutors to take different or assess evidence differently and take different decisions. It is normal, it happens. But my concern was that memorandum was leaked, according to O'Sullivan, by someone inside the NPA. So it means that there was that infiltration by someone in the NPA who leaked that memorandum.
Yeah, no, I see the leakage, but I'm talking here about the decision of the DPP to decline prosecution. You have said to me you don't believe that this decision was correct. And also, there is a memorandum that was written by advocates, which was saying prosecution can continue. But the DPP took a different approach on the matter, which you do not agree with as a seasoned career prosecutor, which also the advocates who wrote a memorandum did not agree with. So it took a unique decision. Now, the question is, you just need to be honest in terms of your own perspective, because we are making different propositions here based on experiences.
Yeah.
Do you think this had ulterior motives? And do you think this is also suggestive of a proposition that Paul O'Sullivan did not only infiltrate IPID, he also had some role players within an institution called the NPA?
Okay, I will leave it to you to make that inference. But what I'm saying is that it is not necessarily that where different advocates differ with the matter. You can see that matter of Katomena. There was one group which said there's racketeering, the other said there's no racketeering. So it's normal for lawyers to have different ideas. That is why even in court, you find a lower court says this, the higher court, then the matter is appealed to the higher court, which differs with the lower court. Then up to the constitutional court, they differ like that. So I cannot ascribe it, save for where they are alleging in the memorandum that my case is a petty case. You have heard now for yourself the evidence that was in that case. So they did not have an opportunity to read what is in my docket, but they just came to the decision that no, that is a petty case. There, I can ascribe some maybe wrongfulness to them.
Okay, this committee, or there's evidence before this committee, which alleges that Mr. Paul, do you know Xhosa or Zulu? You don't know. Mr. Paul O'Sullivan, I just want to say this in Zulu or in Xhosa. Ukuthi ubelala ngengubenye no Jane. No Sarah Jane.
No, that
Now you are saying you made some downloads from Sarah Jane's phone and so on. Even if you don't go deeper into the merits, but did you come across something which corroborates with that allegation? Ukuthi bebenqumelana uSarah Jane beno Paul O'Sullivan?
Unfortunately, I cannot. That is, I would be destroying the state's case if I disclose.
No. It's no longer only the state case, because that we're doing an investigation here also. And I always take offense when people think we're just doing idols or it's a podcast. When they treat this thing as a normal oversight exercise. Here, we do have powers of making an investigation as Parliament.
Indeed.
Two, there is evidence that has been put before this committee, which relates to that aspect. So we're investigating. So we are not jeopardizing anything, but you are assisting us as this committee, because there is a letter, as it has been said by Honorable Ngola, which we got, which says we can't ask about intimacy and so on. Now, as a person who dealt with this thing at your official level, as a prosecutor, even if you don't go deeper, even if you don't give us much details, but would you agree with somebody who says, "Wakungunyelwana"?
I can't.
You can say yes or no, but would you agree with that person? I will move on. I won't probe you further.
No, I have to take into consideration the integrity of the case, because these things are not only ending here. They are going to go to the criminal trial, and then that is why I have to treat the information with the integrity which it desires.
Okay, now let me respect that. On paragraph 103, we were saying, O'Sullivan paid McBride's fees and got rewarded by McBride with involvement in IPID, so he can execute his plan against Pahlane. Let me start this question like this. When did Paul O'Sullivan start to have an interest in the affairs of IPID? Did he start when General Pahlane became his target? Or General Pahlane was part of his or of the reasons which developed interest in him with regards to IPID affairs?
The way I saw it, they started in 2016. If I remember well, General Pahlane testified about an instance where McBride visited the Sable Hills whilst he was under suspension, and tried to talk to him. So they always wanted to bring General Pahlane to their side. Now that they see that he was not playing ball, that is when now all these things
No,
happen.
I'm asking this because I want to understand the mission in its context here. I want to understand what was the ultimate goal.
The ultimate goal.
What was the end goal? Did Paul O'Sullivan engage or impose himself into the affairs of IPID because he specifically wanted to deal with an individual called General Pahlane, or he had a general interest which some did not include General Pahlane?
No, they wanted to take over the criminal justice system, so have their own people installed in those positions according to the evidence of Mr. Cedric Nkabinde, and that evidence is borne out by what is contained in communications there, where they were discussing the removal of General Pahlane, that he must be dismissed. Certain political parties must put pressure that he be dismissed. Certain organizations.
So that interest started way before the establishment of the Pahlane task team.
Yes.
The reason why I'm asking is because the insinuation I'm drawing from this paragraph, when you say O'Sullivan paid McBride's fees and got rewarded by McBride with involvement in IPID, so he can execute his plan against Pahlane.
Yes.
It gives an impression that before the payment of these fees, Paul O'Sullivan was outside the affairs of IPID.
Yes.
He paid this amount because he wanted to pay his way in.
That is true, because he assisted. He also admitted year before the committee that he paid 200,000 rand for the legal fees. So we are saying that is gratification, because the definition of gratification includes the forbearance of.
Yeah, you see where I have a problem, Advocate Mashucha. You are saying, you have just said to me, his interest started way before the establishment of the Pahlane task team.
Yes.
Now, on the other hand, you are saying the reason why he paid this money is because he was outside IPID, so he was paying his way in.
No, he expected to be reinstated. That is why he paid those legal fees. Now, as soon as McBride was reinstated, immediately he approached McBride and then involved himself in the investigations, unlawfully in the investigations against General Pahlane. So that is what we call paying it forward. He paid it forward.
Yeah, there is an excuse which does not accord with logic. Yeah, I think Honorable Sangoni has also asked you about this excuse, and I was not satisfied with your response. I think on paragraph 73, wherein you are saying you decided not to prefer charges against Mahlangu and Binang because in your view, that would impede the Pahlane investigations that they were involved with. The Pahlane investigations were dealt with by IPID, correct?
Yes.
Because Mahlangu and Binang are employees of IPID, are investigators of IPID.
Yes.
And then the charges that you were supposed to prefer against them, you were supposed to prefer those charges as a prosecutor.
Yes.
From the NPA.
Yes.
So now, where do we find the nexus between the two? Does it mean that when somebody is busy with a certain investigation or with certain work, even when there is overwhelming evidence before you as a prosecutor, you can't charge that person because he is busy doing some work elsewhere?
No, you can charge him, but there was no rush because the person who was actually being used to do the intimidation of the witnesses and so on were those two. So if they are charged and out of the picture, those ones we could deal with them at a later.
No,
later
but still advocate, because it's not about whether there is rush or there is no rush. When there is evidence, prima facie evidence, the only responsibility you have is to execute your mandate, is to charge people.
Yes, that is why you can charge people by...
Because you had evidence at hand. I was going to understand maybe if you were saying to us, evidence was insufficient at the time.
No, there was sufficient evidence.
But now we are saying there was sufficient evidence, but
Yes.
you could not charge them because they were still busy with another investigation.
No.
Somewhere.
We did not, we could not charge them. We could have, but we did not charge them, but we first wanted to deal with the actual persons who were committing the intimidations, and that is Sarah Trent and Paul O'Sullivan. Those ones had, we know that they had the mandate to do the investigations. These ones, other two, did not have the mandate. That is why they were used to intimidate people. So we wanted to deal with these two urgently before we get to the actual IPID members.
Yeah, I know that, Advocate, you are very careful of not jeopardizing cases which are before or investigations which are currently underway. I just want to ask you about what you have written on paragraph okay. You are saying here on paragraph 67, O'Sullivan threatened Justa with 2 years imprisonment. So is Justa willing to depose to an affidavit?
Yes, Justa has deposed to, I think, 3 affidavits. If I remember well, yeah, there should be 3.
To this effect?
Yes.
Okay. And then At what stage did you take this matter? Because when you, at the beginning of your statement, you are saying that it was dealt with by another prosecutor who later resigned.
Yes.
But you go on to say, when you took over the matter, you had to establish whether it was possible to continue with prosecution and so on. So following that, is it correct to assume that you took the matter at an early stage when there was no prima facie evidence?
No, there was already prima facie. I was referring to a prosecutorial decision. Remember, if I receive a docket, I have to make a prosecutorial decision whether there is sufficient evidence to proceed or not. So there were already those statements of Jooste. Then I instructed that the investigating officers go and obtain further evidence. And I even went to consult with the witnesses myself. And then from there, they came out a whole lot of these statements that were sent to Jooste. He then also talked about them. So I had to request the instructed the investigating officers to obtain further evidence. That is why thereafter I charged the accused.
So let's say you had not resigned as the prosecutor from the NPA and you would still be dealing with this matter even by now.
Yes.
Maybe to how far would you have gone at this stage? Would be still, if the matter was still in your hands, would be still complaining about it being stagnant? Because the complaint or the concern that we have here is that, one, it's unjustifiable that a decision to strike it off on the basis that more witnesses have to be added was taken in 2017, correct?
Yes.
And when you calculate time from 2017 to date, that's a very huge period. So would it be in the same position now if it was still under your hands?
I can say that I'm very happy that the matter is being considered, and it is the NPA is.
But when has it been reconsidered, Mr. Advocate Mashuka?
There's a letter from the NDPP which indicates
Thank you
that
so much, the Democratic Alliance.